Thanks for joining me today. We are talking about Medicare secondary payer and the impact on New York workers' compensation settlement. So I hope everyone's summer is going amazing. Thanks for joining me today for this topic. And I'm going to do my best to make this topic interesting, timely, and relevant for those of us who are defending or handling New York workers' compensation cases. I know Medicare as secondary payer is a kind of topic that is not that exciting, so I'm going to do my best to make this as relevant and useful and practical as I possibly can. Now, just as a reminder, this is not advice as to any particular case. I am not your attorney just because I'm giving you this advice. Also, please be reminded, this is a live webinar. A lot of people are listening to this back in recorded format. We do post the videos on our website as well as the audio as a podcast. But if you're joining me here today, it's because you want to ask me questions, maybe about this topic or maybe about any issue in workers' compensation law. So take advantage of the fact that you are here today live. Please ask me questions. You can type them right into the box, and I will do my best to answer every question I can on any issue really in New York workers' compensation law, but hopefully about Medicare as secondary payer and how that impacts your settlements in this area of the law. But please ask me questions. I will always read your question out loud so the entire audience can see it. I will only say your first name so you know that I'm answering your question, and I'll do my best to answer it for you. I will never say your last name, and I will not embarrass you, so please go ahead and ask that question. If you're thinking to yourself, hey, this question is kind of rudimentary or simple, maybe I shouldn't ask it, please do. There's somebody else who's listening to this on either a podcast format or playing it back on video who would have loved to have asked that same question. So please go ahead and ask it, and again, I will do my best to answer it. Our topic today is Medicare as secondary payer. And of course, I'm going to just start off by saying this is an area of law that is going to change, I think. Why? Well, the Supreme Court in the Loper decision just overturned Chevron, which says that we're not to be granting deference to the rulemaking authority of government agencies. And a lot of what we're going to talk about today is not found in the statute, and it is certainly not found in case law. It is found in references and guidelines and rulemaking that's been done by the Center for Medicare Services as they have administered the Medicare as Secondary Payer Act. So if you're wondering if stuff that the Supreme Court does at the federal level sometimes impacts us and how we're going to defend cases at the state or local level, absolutely. This is going to be one of those issues where I think there's going to be some opportunity to challenge some of the rulemaking that has been gone on over the last 20 plus years. The fact that the Center for Medicare Services has been relying on memorandums and reference guides and other things that are non-binding and maybe exceeds their authority to do. So this is, I think, going to be an interesting area, and I'm going to, again, do my best to make this as timely and relevant as I can. So I'm going to talk a little bit about what this Secondary Payer Act is, why we should care about it, what's our obligations and why we care, and then what we have to do about it. So how it's going to actually guide us or how we're going to be forced to respond. I'm also going to talk about, and I really want people to understand this when I'm done, what the difference is between a review threshold and the requirements of the Act. This is the biggest place that people screw up. And in fact, it's the biggest place that I see adversary attorneys screwing up and defense attorneys get confused. And they'll say silly-hearted things to you as the risk professional or the employer or the carrier. And they'll say stuff like, oh, well, I'm going to settle this case, but I'm only settling it for $20,000. And because I'm settling it for so small, we don't have to worry about Medicare. No, that is per se malpractice right there. That's an absolutely false statement. So if you're walking into this presentation with those kinds of ideas in your head, well, if the case settles for a small sum, I don't have to be concerned about Medicare. I'm going to try to address that and rectify and correct that today. Okay, so I'm hoping we walk out of here understanding that. All right, so here is the Medicare as Secondary Payer Act, 42 U.S.C. 1395Y, and I have selected some of the sections to highlight for you. What does this act say and what does it mean? It just essentially says that whenever there is payment by Medicare for a service that should have been made or reasonably could have been expected to be paid by the workers' compensation carrier or employer, that Medicare gets its money returned to it. That's it. It's essentially saying that Medicare is always secondary to workers' compensation. And because, again, the topic today is New York workers' compensation and the impact of Medicare on it, that's the impact that we're talking about. Our workers' comp exposure, our liability, our responsibility, whatever word you want to use for what we're exposed for, is always primary to Medicare, and Medicare should never be asked to pay for treatment that should have been rendered under the workers' compensation program. Now, wouldn't employers love for that to happen all the time, right? I mean, think about it. Who gets the best deal with doctors and hospitals, us or Medicare? Medicare is paying pennies on the dollar compared to what workers' compensation is paid. In fact, the fee schedule in New York is essentially cost plus, or not cost plus, it's Medicare plus, right? They just add a percentage onto Medicare. So, you know, if employers could get away with this, we would all the time. We'd say, hey, you're Medicare entitled, awesome, use your Medicare card, and then whatever Medicare paid for the treatment, we'll pay you back, or we'll pay Medicare back, and we'll get a discount, right? We get a big discount off of the fee schedules in this jurisdiction. Well, that is not just wrong, but if we are caught doing that, we could be exposed for double whatever Medicare paid. So that's the penalty that I'm going to talk about in just a little bit. It's important that we comply with the requirement that Medicare is always secondary to workers' compensation because the statute contains a penalty, and that penalty is that we could be liable for double the amount that Medicare incorrectly paid. Okay, and this is the way that Medicare is attempting to make sure people don't use this as a way to pay less. Again, if you think about a state like New Jersey doesn't have a fee schedule. We're paying huge amounts for medical care in New Jersey. Employers would love to say, I'll pay you whatever Medicare pays you, right? And we'll just pay Medicare back. So they built this penalty in to discourage employers from doing that. So who's liable to pay that penalty? Well, the statute says that anybody involved in the workers' compensation case could be liable to pay that penalty. It could be the claimant, it could be the employer, or it could be the insurance carrier. But guess what? Who's going to have money in their pocket? It's generally going to be us, the insurance carrier or the employer. They rarely are going to get any money back or issue a penalty to the claimant. And in fact, when they do find a willful violation on the part of the claimant, generally what they'll do is suspend their Medicare benefit until that amount of money has been not paid out on behalf of that claimant. So in other words, the claimant will continue to go get medical care, and Medicare will simply say, well, because you already took $10,000 of medical treatment you were not entitled to, we're just not going to pay for the next $10,000 of treatment. That's just how that works. But what's really dangerous about this statute, and the place for a lot of focus for us, is that same penalty applies to any future payments that Medicare may have to make in the future. So we're not just talking about payments that Medicare's already made, but if we resolve a case in such a way that Medicare has to make payments for medical treatment for the claimant in the future, we could be exposed for all of that future liability. And again, you know, my job is as an attorney to protect my clients from future exposure and liability. So this is something I want to desperately avoid. What cases are impacted by this Medicare Secondary Payer Act? Well, it's not all cases, right? There's only two distinct classes of cases that fall into this sort of exposure trap. The first one is cases where the claimant is already entitled to Medicare. And also, by the way, when I say Medicare, I just want to say in general, I'm also talking about Medicare Advantage plans. And the reason I'm saying that out loud is because if you ask some people that are on Medicare right now, you go, hey, are you on Medicare? They're like, no, I got Blue Cross Blue Shield, I got Aetna, I got Horizon, Blue Cross. And you look at the actual card, and it's actually a Medicare Part C card, right? Because they're on an Advantage plan card that looks like it's administered by another party, right? So when I say Medicare, just going forward, just understand I'm also saying Medicare Advantage plans. So the cases that are impacted, well, the first is any case where Medicare has made a ready-made payment for treatment that we should have paid for, okay? The person, maybe by accident, I think most of these violations occur by accident, was injured in a workers' compensation accident, they injured their low back, and they went to the doctor and they presented their Medicare card by accident. They should have said, hey, wait, charge it to the workers' comp carrier, and instead they took out their Medicare card. So that payment really needs to be reimbursed to Medicare. Okay, that's the first type of case. Think about that. That person's already entitled to Medicare. They have a Medicare card, and again, they might have utilized it by accident. The second kind of case that's impacted is where we are closing our case full and final, which means medical is going to be included in that, and the claimant might someday in the future charge their care for their workers' compensation injury to Medicare, okay? So that's really the second part that's a little bit more dangerous and harder to predict, and we have to be a lot more cautious and thoughtful about that. Okay, that's where I'm foreclosing future medical. You know, we all think about New York Section 32, lump sum dismissal. Here's your money. Your journey with us has come to an end. Goodbye, sayonara. And oftentimes we'll do a Section 32 that includes future medical. Every case that you close pursuant to Section 32 that includes future medical, you need to know the Medicare status of the claimant before you do that settlement to make sure that there is no potential that in the future you're going to expose Medicare for that person's medical treatment. Okay, now we talked about the two types. Let's go into a little bit more detail. The first type, Medicare has already paid for something we should have paid for medical care we should have paid for. That payment that Medicare has made, the term of art for that is a conditional payment, okay? And the second kind of case, Medicare might maybe someday in the future have to pay for something we should be responsible for. That's called Medicare's future interest. All right, so you're going to hear those two things talked about from this point forward in this presentation. And these are the terms of art that we as practitioners are using. When it's a bill that Medicare has already satisfied, we'll say that's a conditional payment and that we have to reimburse Medicare for that bill. When it's a future exposure that by doing a lump sum dismissal, I'm helping my client avoid, that might involve Medicare's future interest. And so those are the two times that we get involved in these cases. Now, what kind of cases are we talking about in particular? Like, how do I know that the claimant might be entitled to Medicare? Well, first is, hey, are they over the age of 65? Because they might be getting close to their Medicare entitlement age. Have they already been on Social Security disability for more than 2 years? And this is really common, right? Unfortunately, these New York workers' comp cases, they drag on. And while they've been dragging on, they've been out of work for years, they become entitled to Medicare because they went on Social Security disability in addition to collecting their state workers' compensation benefit. So simply being on Social Security disability for 2 years entitles you to Medicare at the conclusion of that 24-month period. And the dangerous part about this, and the thing I want us to be mindful is, your award of Social Security disability benefits can go back. It can be backdated. So we have to be very thoughtful about when that person was actually entitled to Social Security disability payments. And of course, when I start talking about older claimants, I start talking about claimants who might be entitled to Social Security, who might be already deemed totally disabled, you know that I am talking about our oldest and most difficult to close files, right? These are the ones where we spend the most amount of time, blood, and treasure trying to dispose of some of these claims. So how do we know the person's Medicare status beyond that, those suspicions or those case types that should raise those red flags? Well, sometimes our client or the employer or carrier will tell us. They are doing a query match with Medicare's system. In other words, there is a computer interface that they can go through and they can tell us, hey, Greg, I'm sending you this case. And by the way, the claimant's already entitled or might become entitled soon. So that's a great way. Now, in every single case that I defend for clients, and I do think this is best practice, I think all defense firms should be doing this in all practice areas, is whenever you're defending a case, you should always serve a request for information to the opposing counsel. And you should say, I need to know if your claimant is on Medicare, okay? And we actually send out an affidavit in our office for opposing counsel to have their client complete, which requires them to tell us if they are or are not receiving Medicare. Sometimes the claimant will tell you, by the way, I'm on Medicare, or I have a Part C plan, so that's something useful for us to know. Sometimes opposing counsel will tell us. They'll say, oh, Greg, by the way, this case that's been going on, the claimant just got entitled to Social Security disability, and by the way, they backdated it 2 years, and they are now also entitled to Medicare, okay? Unfortunately, and I hate surprises, right? I hate surprises. That stuff is sometimes shared with me for the first time when settlement negotiations are ongoing. So we're starting to talk settlement, we're starting to talk about resolving the case, and my opposing counsel all of a sudden goes, oh, and by the way, Greg, my person's on Medicare, right? So they've just made the case more complicated, okay? So that's something to be mindful of. Oftentimes, too, we will simply recognize, hey, this person is 72 years old. The accident occurred 6 years ago. There's a strong likelihood that they have a likely entitlement. Okay, what happens when Medicare pays for treatment we should have paid for? Again, I told you that those are called conditional payments. When Medicare pays for care related to this workers' comp case that we're defending, we have to reimburse Medicare. It's actually pretty simple. And the Act itself, the statute says that we have to make this reimbursement. It's relatively straightforward. Medicare will issue a conditional payment letter and says, hey, here's all the payments we made. We think you should have paid for them. The recovery contractor has made this very simple, by the way, for claimants to interrogate their system and get these payment letters sent to them. Again, these are called conditional payments, and that's why the letter will say this is a conditional payment letter. Now, my best practice here is that we always go through and review these conditional payment ledgers that we receive from Medicare. Medicare will issue this and say, you owe us $31,000 for medical treatment that we've provided you related to your workers' comp case. And we'll look through that and be careful. Those CPT codes should match. If you have a right shoulder case, it should be orthopedic treatment for the shoulder. If you see treatment in there for male pattern baldness or halitosis or sleep apnea or some weird stuff, that should not be related to your workers' comp case, so you can challenge them. In general, Medicare does a pretty good job of detailed matching their conditional payment demands to what treatment actually, or to the injuries in the actual case. But again, go through that, double check. That's part of our role in doing due diligence. Okay, second issue is, and again, conditional payments, in my opinion, are quite simple. It's really, hey, someone else paid for something you should have paid for, just reimburse them. Okay, very straightforward. The type 2 case is, or the second time that we're going to interact with Medicare, is when Medicare might have a future interest. What does that mean? It means Medicare might be exposed in the future to pay for medical treatment that we should have paid for. The Act very specifically says that Medicare must not be charged for any medical care that could be reasonably expected to be paid for by the workers' comp carrier. So how do we make sure that doesn't happen? How do we make sure that our clients are in compliance with the Act? How do we make sure that we protect somebody's future interest, right? This is not as straightforward as it seems. So interestingly, the way to protect a future interest is any way that you could come up with that protects Medicare, okay? And we've been very creative in the past, and if someone wants to come up with creative ways of doing this, I can help them. But in general, the set-aside arrangement has emerged as the preferred way to comply. And what we're essentially doing is taking some money and putting it aside for the claimant's future medical costs. So in addition to their workers' compensation Section 32 settlement, they're also receiving a second envelope of funds, a second check, a second bucket of dollars to pay for that future medical care, which we say might have been related or necessary in our workers' compensation case if our case had gone forward, or if we had settled it in any other manner than a full and final lump sum dismissal. And Medicare has come up with a reference guide, which again, I believe is subject to attack under Chevron, that provides methods for how we calculate that future amount. Now, I'm going to say this up front, I'm going to say this many times. There is no requirement that Medicare review or approve the proposed set-aside that you're going to include with your settlement documents. There's nothing. But they will under some conditions, and I'll talk about those conditions in a little bit. So what has to go into the set-aside? Well, the set-aside should contain a good faith estimate of all the medical costs that would have been paid by Medicare in the future, if not for the workers' comp case. And it has to cover the expected lifetime of the claimant. Medicare uses rated ages to estimate life expectancy, which does take into account comorbidities. The other thing we should be thoughtful about, and here's a little note on the bottom of the slide, is that since 2004, prescription benefit costs have been included with Medicare benefits. And so that has to be taken into account. And as we've seen, prescription costs have been a real driver in expense and driven up the cost of set-asides. Simple cases where the claimants may be taking some pain medications, we see really large set-asides there. And sometimes the set-asides are so big that they blow up the settlement. I mean, a person might have a relatively simple low back case, but they got a lot of care, a lot of treatment. Maybe they've been on pain management treatment for a long time, and we're going to settle their workers' comp case for $100,000, but that Medicare set aside, that future medical cost, comes back at $400,000. Well, that doesn't make the settlement of that case very attractive to me or my client anymore because of the amount of huge payment that we might have to make into the future. Also, it doesn't, in my opinion, take into account the fact of life, which is once you give people a big lump sum of money, they don't really go pursue medical care anymore because the medical care was really being pursued to drive up the value of their workers' comp case. Let's be frank about the jurisdiction we're in and how this game is really played by claimants counsel. I mean, these are basically predators. They prey on you. They encourage their their clients to go get lots and lots of medical care to drive up the value of their comp claim. Our experience has been once you settle cases, they don't get care anymore. So again, those are some of the challenges theoretically with the set-asides. A set-aside may contain other things. So you could put an annuity in there that pays a fixed sum for a period of years. You can add provisions that the set-aside is self-administered, or you could have it professionally administered. A self-administered set-aside simply means the claimant gets a second check and they are responsible for spending it appropriately on medical care only. Now, when I say they're responsible, I mean, what do they really do with these set-asides? Often they embezzle them from themselves and just go out and buy a fishing boat or go on a great vacation. It's not until they present their Medicare card for that same exact medical care that's related to our workers' comp case that Medicare is going to take an interest in that. And again, as I just told you, oftentimes when you settle a case full and final, the person never gets any more medical care because that medical care was only being obtained to drive a settlement in their case. I'm sorry, I've been at this for a couple decades, people. I maybe have become a little jaded, or this could just be the benefit of experience talking. You can also financially structure the set-aside money using annuitizations or seed monies, and you can also have a requirement that the employer carrier has a reverter interest in the annuity if the claimant dies. So you could do all of those things. Now, future medical is, how is it estimated and how do we come up with these sums of money? Well, the reference guide, which is published by the Center for Medicare Services, the recovery team, does have a recommendation or a recommended way. And they will also tell you that once you come up with what you think the proposed set-aside is, that they will review it if it meets certain conditions, and they'll tell you how they're going to do it. And they say, we're going to review whatever you submit, and we're going to take in consideration the claimant's injuries, their comorbidities, their past use of healthcare services, and we're going to use evidence-based rationale for their determinations, taking into account published guidelines and current peer-reviewed medical literature. Okay? But in truth, what we find with the reference guide method is generally they're using a lot of an actuarial basis. They're just saying, here's the medical care that this person received for the last 6 months. They're expected to live X number of years, and here's how big the Medicare set-aside should be. And it ends up with these giant numbers. You will have options, though. You don't have to use that method. We have clients that use what we call an evidence-based method. There are many vendors out there that will compute or come up with what they'll call a real-world pricing strategies for these set-asides. And again, some of these products or these offerings will say very specifically that this will be lower than the reference guide method. Okay, again, that's fine. You can also have your attorney come up with what they think the right set-aside is as well. So you could have a legal opinion give you an opinion as to what the size of the set-aside should be. Now, when do we need to do the set-aside? What is the requirement? Well, the law says that when the claimant is Medicare entitled and the settlement of the case will end the claimant's will end the carrier's responsibility for future medical, you must get a set-aside. Okay, that's straightforward black letter law. The reference guide issued by the Center for Medicare Services will also say that when the claimant is reasonably expected to be Medicare entitled within 2.5 years of your settlement, and the settlement is large, meaning over $250,000, and the settlement ends the workers' compensation employer or carrier's responsibility for future medical, then you should also get a set aside. Okay, again, that's subject to interpretation, and it is, again, not in the statute. It is coming from the guidelines that are issued by the Center for Medicare Services. So what do they think is reasonable, or a reasonable expectation that the claimant will receive Social Security benefits? Well, it says the claimant has applied for them. They've been denied them, and maybe they're considering appealing that. They're in the process of appealing the denial of Social Security disability benefits. Or they're 62 and a half years old, meaning that in the next 30 months they are likely to be entitled. Or they have a qualifying condition, and the specific enumerated qualifying condition is end-stage renal disease. So that's when we need to get a set aside. Now let's talk about review thresholds, because this is a completely separate topic. So you may have to get a set aside based on the claimant's Medicare status. And then you have a choice. You may choose to have Medicare review that proposed set aside and bless it with an approval letter. It's an entirely optional process. Of course, some of our clients say, Greg, I want to get that special blessing, that excellent letter that I could obtain that's makes my warm security blanket. I can wrap myself up in it when I go to bed at night and say, look, I got this wonderful approval letter, and it makes me feel good that my set aside is correct and fair and just and reasonably expected to protect Medicare's future interests. So I say, I feel good about that. So, okay, you want to do it, we'll do it. And it's not required or mandated by law that you get a approval letter, but some clients want to do it, and they think, hey, we should do this in every case. They say, okay, you're risk averse, you want to do this, I will help you, no problem. However, Medicare is not going to look at every case and give you an approval. They're only going to give you an approval letter or review your case. So the first review threshold is if the workers' comp settlement is over $25,000. Okay, now this just means that for little rinky-dink small cases, $10,000, $5,000 lump sum dismissals, Medicare says, I don't want to look at all these little rinky-dink settlements, so we're not going to review those proposed set-asides. Guys, the amounts of money in dispute are just too small. We don't have time to look at those, okay? That doesn't mean that you have a safe harbor and you don't have to consider Medicare's interest if your case settles for less than $25,000. It just means that Medicare's not going to review whatever you come up with as fairly and adequately and justly and fully protecting Medicare. They just don't have time for that because you have a small case, okay? It's a minor issue. This is one of the chief problems I have with particularly adversaries. They'll say, hey, Greg, can't we just settle this case for $22,500? That way we can settle this case and we don't have to worry about Medicare. I'm like, you do have to worry about Medicare. They just won't review it, okay? So what they're confusing is a review threshold with a safe harbor, and these are totally different concepts. So the first review threshold is Medicare will look at your case if the proposed if the settlement is over $25,000 and the claimant's currently entitled to Medicare. The second review threshold is what if the claimant's not currently entitled to Medicare, but is reasonably expected to be entitled soon, and it's a large settlement. And so Medicare has come out and said, look, we can't look at all of those. There'll be too many of them. So where you have a really big settlement, the settlement is over $250,000 in your work comp case, and the claimant's not currently entitled to Medicare, but might be soon, then we'll look at the case. All right, so these two review thresholds, and really the key thing I want you to take away here is that a review threshold is not a safe harbor. So just because we're talking about these numbers doesn't mean that these cases don't have to be reviewed. And I can't stress this enough, it's one of the most common errors I still see today. Now, what are your options when a set aside is necessary? And I want to go through this a little bit too, because I want people to think about where they fall on sort of the risk management scale. Are you a belt and suspenders type of person or not? And we want to tailor to our clients what they want to do. And I have clients that are all over the board. Some are extremely risk adverse. They're really trying to be as compliant as they can be, even going overboard. And they're going to take a very specific approach to their Medicare set aside obligations. Secondary payer obligations. And then I have some who are a little looser-goosey, and they'll say, hey, look, we get what those obligations are, but we also see the downsides of reporting or not reporting, of asking for review and approval of every single one of our proposed set-asides. And so for that reason, Greg, we're not going to ask for them to be reviewed by Medicare. All right. Along that continuum, clients fall, and we're going to adjust how we make sure that they stay in compliance according to what the client preference is. Okay, so you can submit your set-asides for prior approval based on the reference pricing guidelines. And if you get that Medicare approval in your hand, you're going to have the lowest risk of potential problems down the road with compliance. But you're also going to have, it's going to take some time. Usually takes a couple extra weeks to get Medicare to respond and give you that approval. And I'm going to tell you, just my experience is, you might have a higher exposure because you're using Medicare's reference guideline, which is a little bit more doctor biased rather than evidence-based, and you might have a higher exposure. So that's something to weigh. Okay. The next choice you have is doing something like an evidence-based set-aside. There's a lot of vendors out there that will prepare that for you. And then make a choice based on whether you're going to submit or non-submit for prior approval. I'm going to tell you, your risk is going to vary depending on your submission status. Less exposure likely, again, because you're using a more aggressive medical pricing method, but potentially a compliance risk in the future. Now, in my opinion, and I'm just giving you this as my opinion, as someone who's done this for a long time, I still think you have a very low compliance risk by doing that. Okay, I advocate for that all day long. The other choice you have is you could do a legal opinion-based set-aside. In other words, you have an attorney, and there's many attorneys or vendors, attorney vendors, literally law firms, that specialize in writing Medicare set-asides, and these can be quite aggressive in the way they're written. And you're basically with that done risk shifting, right? Because you're getting a legal opinion about what your proposed set-aside should be in the future. It ends up becoming the attorney's risk, right? It's a legal opinion. It's subject to their malpractice coverage. And obviously they should have large malpractice coverage numbers. You should be asking of these vendors or entities that are providing these legal opinions, because that is going to be your safety blanket in the future. You've essentially shifted your risk to the attorney by asking them to write their own letter and cover you. All right. Now, in practice, my practice, I generally recommend against the pre-approval of set-asides simply because of cost and delay. I believe this leads to quicker settlement approvals with not really any downside, but I understand that clients might have their own risk management guidelines in place that require that all their set-asides that meet the review thresholds be approved for review. So that's our standard operating procedure here. I do think that is best practice in the industry in general, and that's what I counsel other attorneys to do. So that's generally how we approach it here, and I hope that's helpful. So what do we do? And when you're thinking about Medicare and how it's going to impact your cases and your secondary payer obligation, best practice is identify cases early. We should be doing this early to determine that Medicare's current or future interest needs to be considered, right? Are there going to be a conditional payment? Am I going to have to prepare a set-aside if I do a lump sum dismissal? And again, when I wake up in the morning and I put on my lawyer costume, I want to do lump sum dismissals. I want to get rid of these cases as quickly and efficiently as possible. I also advise most of my clients that we do not recommend seeking a Medicare-approved set-aside, but again, if that's something they prefer to do, we don't stop them. And we are always prepared to educate our clients and help them choose their options and do what's best for them. All right, my final takeaways for everyone. Medicare's interest has to be considered when there's been a conditional payment, meaning the claimant's already eligible, or they're eligible and the case is closing by way of full and final. Be thoughtful about this. This is not something to ignore. I also want to admonish everyone, a review threshold is not a safe harbor. We just talked about that. And please do not wait for settlement for your first crack at saying, hey, wait, do I have to take Medicare's interest into account? Do I have potential exposure or obligation here? Like, we shouldn't be waiting to the end of the case. All right, let's go to some questions and answers. And I can already see that we have some questions today. So let me pop in here and see what we got. All right, so first question I'm going to answer, well, we got a whole bunch of these from Anna, so let's see how many of these I can answer in the time we have. Let me just open this window up a little bit bigger so I can see your questions. All right. Anna says, Greg, if there is she's saying, I can't hear you. I hope you can. Test, test, test. Yeah, it's working. Can't hear me? Yeah, it's working. Okay. I can now, she says. Okay. Oh, cool. All right. All right. So Anna's first question is, Greg, if there is a Section 32 agreement, what is the time frame, if any, before a patient can use their Medicare for future care? Well, the answer is never. Okay. That's the answer. If you do a Section 32 lump sum dismissal settlement in New York, or in any other jurisdiction, you have a lump sum settlement that forecloses future medical. You've included medical. You said, I'm paying you this lump sum of money. I am never paying for any of your medical care in the future. They can never, there is no expiration date. There is no statute of limitations in the Medicare Secondary Payer Act. If 20 years later, they take out their Medicare card and use it to pay for medical care that should have been related to that workers' compensation case, we, the employer carrier, could be exposed. Okay, and by the way, Medicare secondary payer law has been on the books since the 80s. It just never was enforced or regulated. I shouldn't say regulated, but they didn't really do much rulemaking around it until 2003, when they started issuing a series of memos. And they started, I'm sorry, I think it was 2001. They started issuing a series of memos saying, we're going to start enforcing this thing that's been on the books for 20 years. Okay. Anna says, Greg, if a body part has not been established or is controverted and still denied after the hearing, can Medicare be billed? All right, so that's a great question. Where you're disputing body parts and you're specifically excluding them from the workers' compensation case, you've got a strong argument that, hey, Medicare really, this was ruled out. Now, Medicare will, and they've said this in multiple memorandum, they've said, we will accept a judge's decision, any issue that's been adjudicated, any body part that you've had ruled out or eliminated, we will accept those state level decisions that body part or that condition is not related to the workers' compensation case, and you can successfully exclude it from your set aside. But if it hasn't been, and you are dismissing the case or and there are disputed body parts, you still have to take Medicare's interest into account. Does this apply to health insurance carriers? Of course it does, right? If your health insurance is primary, and they should be paying for it, not Medicare. Medicare says anybody who's a first party payer. And again, that would be us as the workers' compensation carrier. Peggy says, Greg, I've got a question. I know this is a New York webinar, but does it apply to all states? The answer is absolutely yes. All states, all jurisdictions. So in New York, we have something called Section 32 that allows for a lump sum dismissal of the workers' compensation case, and you can include medical, right? So when you do those Section 32s, that's when you should be triggering off, wait a second, do I have a Medicare exposure issue here? Do I have a secondary payer obligation that I have to take care of? In New Jersey, right, we've got a huge New Jersey practice here. Please send me your New Jersey cases. We have something called Section 20. It's very similar in function to Section 32 in New York. It's a lump sum dismissal. It disposes of all of the future medical in the case. I have to take their Medicare secondary payer obligations into account. We defend Longshore cases here, right? Longshore has what's called an 8I settlement under Section 908 of the Longshore Act. Very similar. You could do a 908 Section 8I settlement and say, we're disposing of our future medical exposure. We have to take Medicare's exposure into account. So it doesn't matter. This actually applies to all jurisdictions equally. Whenever you are foreclosing your obligation for future medical, or wherever the claimant's Medicare entitled and may have charged Medicare for that treatment, you've got to take that obligation into account. Okay, Miguel asked me the question, Greg, if a set-aside was submitted a few years prior and Medicare's opinion was much higher, could one forego their recommendations or review for a possible new settlement, or are you limited to that old review? Okay, so this is the danger of submitting for Medicare's approvals. Is that Medicare oftentimes will come back and say, oh, you said that you're going to put $68,000 aside for future medical. Cute. We think you should put $98,000, right? So now you've got to fund a much higher set aside. Can you challenge that? Yeah, you could resubmit. You could say, well, thank you for that information, but we think you should take this into consideration and have them rethink it. So it's not final. These approval letters are not binding in that way. However, once you've got their opinion, if you don't do anything about it, you are going to be stuck with it. Again, you could go forward with your original settlement anyway, but you have to understand the risk you're taking on board when you're doing that. That 10 years from now or 15 years from now, Medicare could reopen that case and go, wait a second, why are we paying this? We thought there was a set aside here. How come that wasn't utilized? And that could be potentially one of our issues or problems. Okay, so just be thoughtful about that. All right, that's all the questions I got today. And these were good questions and they were on the topic. So that's great. So thank you everybody who asked me a question, and I hope I got to all the questions that were asked. So a couple little things, shameless plugs. If you like today's webinar, if you like this kind of information, please go to our website, sign up for our newsletter, because we're going to keep you informed of what's changing out there. If you want what's next level, I would say go to see my partner's podcast. It's called Third Fridays. It's released on the third Friday of each month, and it is on generally a high-level topic in workers' compensation, and usually pretty interesting stuff. So go check that out. In the meantime, I hope everybody has a great rest of your summer. Again, I just started seeing commercials for back-to-school sales and back-to-school supplies. So I guess summer's coming to an end. I hope you've had a wonderful summer, and we will see you next month with our next presentation. Okay, bye everybody. Have a great day.